chairman of the Rajya Sabha rejected the motion moved by members of the Rajya Sabha for the impeachment of the Chief Justice of India. To say the least, the order is unprecedented, illegal, ill-advised, and hasty. Why is it unprecedented? Because never before in the history of India an impeachment motion moved by members of parliament has been dismissed at the preliminary stage. Therefore, it is unprecedented. It is illegal because the chairman has passed an order which is required to be passed after a full-fledged inquiry. Let me now explain to you what the procedure in law is. If 50 members of the Rajya Sabha move a motion for the impeachment of a judge, that motion has to be dealt with by the chairman, not in his judicial or quasi-judicial capacity. He has to see whether the motion is in order or not. Have 50 members signed it or not signed it? Are the signatures genuine, not genuine? Is the motion in order? Is the motion in order consistent with Article 124 of the Constitution? And if it is absolutely frivolous, means it has nothing to do with misbehavior of the judge, he can take a call. He doesn't act in any quasi-judicial capacity at that stage. Once the motion is admitted, then under the Judicial Judges Inquiry Act of 1968, the motion is sent to a panel of three. One sitting Chief Justice of a High Court, a judge of a High Court, and a legal luminary. Judge of a Supreme Court and a legal luminary. Then a full hearing in the sense that evidence is laid, documents are submitted, witnesses are called, and the inquiry committee either comes to the conclusion that the charges are proved or not proved. If the charges are proved, then the motion is in the form of an address to the President of India for removal of a judge for proved misbehavior. Why? Because the Judges Inquiry Committee, after taking evidence, finds that the charges are proved. So proved misbehavior comes after the inquiry. It cannot come before the inquiry. Right? So that is why it is illegal. Because the chairman of the Rajya Sabha has said that we've not been able to prove misbehavior. he says the prefix proved places an obligation of actually proving the misbehavior before the parliamentary procedure starts. How can something be proved before it is proved? It can only be proved after an inquiry. It can't be proved before an inquiry. So it is illegal. 3, it is ill-advised. Why is it ill-advised? Because the procedure requires him to consult the Chief Justice of India before he admits the motion. Now, he can't consult the Chief Justice of India, obviously. So he should have consulted members of the collegium. He has chosen not to do that. Some of the allegations relate to what is happening in court. He has not consulted any judge about what is happening in court. One allegation is that he sends matters to particular, most sensitive matters to particular judges. He should have consulted why judges feel disturbed about that. So without consulting the judges in respect of matters that happened in court, it was ill-advised of him to reject it. And last of all, hasty. What was the tearing hurry? If a motion is moved by the signatures, valid signatures of 64 members, which he admits, and there is a whole petition moved with documentation, excerpts of conversations and other things, obviously it takes time for any normal person, even I as an experienced lawyer, I must say that it takes me time to understand an issue because I'm not superhuman.